this great panel together for our gene discussion right after the more doctrinal type of lecture. I'd like to personally thank, especially thank Mr. Zachary Kinnaird for setting this thing up. He did most of the legwork, and Professor Ann LaFaso and Margaret Obush for helping to organize a lot of the procedural things that go together to put the event together. So to introduce Professor Risch, he's one of the preeminent up-and-coming law professors in intellectual property. He received his AB in public policy from Stanford and then went on to receive his JD from the University of Chicago. He was an Olin Fellow at Stanford and then went on to become the director of the Entrepreneurship Clinic here at WVU. He's now an associate professor at Villanova University and is doing a lot of really interesting research and pushing the boundaries of intellectual property. So these are just one of many of his professional qualifications, which clearly establish him as one of the luminaries in intellectual property law. But really, these qualifications don't tell you anything about him personally. He's amazingly generous with his time and was universally loved when he was here at the university. Just at our breakfast, I can see when people come in and see him, their eyes light up, and he was truly missed when he left here. Professor LaFaso told me I had really big shoes to fill when Professor Risch left, and I think this is really true. So without further ado, Professor Risch.
Thank you. I'm flattered and embarrassed. Professor Tu has filled those shoes quite well from what I've seen so far. West Virginia will always be my first academic home, and I'm thrilled to be back here to speak to you today. And the topic I want to talk about is rethinking patent quality. And let me tell you what I mean by that. There are two parts to this talk. The first part is that patents are not just about patent trolls anymore. And you may not know what that term means. I'm going to tell you in just a minute. It may never have been about patent trolls. And so if it's not about patent trolls, then we need to look at a different way to think about patent quality in this age of high-stakes patent litigation. And I plan to do that from both the macro and the micro level. Here's what I mean by that. Macro and micro in economics have some very specific meanings. Micro is the study of individual decision-making, individual markets. Macro is how we look at society as a whole, monetary policy, how much money is there, government spending, etc. I think this general framework applies to patents. I think we can look at patents on the macro level. What does it mean for society to have patents? What does it mean to have a group of patents or a patent portfolio? And then we have the micro level, which is how do individual cases get handled? What do individual patents look like? These two things, I think, are related, but the intermingling of them often gets lost. So I want to end this talk, when I eventually get there, at looking at how we can link the two together. But first, some background. Patents and NPEs. So let's start at the beginning. The patent grant is the right to exclude somebody else from practicing the patent. So if I have a patent on a pen, that means if somebody else makes, uses, or sells a pen, I can sue them for patent infringement. The quid pro quo for this, of course, is that I must actually have invented the pen and given it to society. And so we say that there's an incentive to both invent and to disclose the invention to the world in exchange for this right to exclude. Because the right to exclude is very broad. You don't have to copy a patent directly in order to infringe it. You can be sued for infringement having never heard of the patent in the first place, and in fact studies have shown that most patent infringers never heard of the patent. They're absolutely surprised by it. The other thing to know about patents is this right to exclude is transferable, meaning if I invent something and get that right to exclude, I can transfer it to somebody else so they can sue you instead of me. This makes a lot of sense When we talk about employees, employees will make inventions, they will get patents, and then they will assign them to their employers. So, for example, when we talk about IBM getting more patents than anybody else, IBM, the company, doesn't invent anything. IBM's employees invent them, and they assign them to the company. Another way we might see transfers is company acquisition. A company will be purchased, and along with it comes the patent rights. Or a product line will be purchased, and along with it comes the patent rights. But here's the third way patents can be transferable. To anybody. You or me or somebody down the street can buy a patent they think is valuable and start suing people. This third group, everybody, leads to what we call NPEs, or non-practicing entities. They might also be called PAEs, patent assertion entities. In essence, they are entities that don't make anything. They buy patent rights, and then they try to make money by suing or by licensing out the patent rights to other people. Because without that patent right, they can sue to exclude, and the right to exclude means you can get an injunction. Some people call these NPEs patent trolls. Patent trolls are proverbially the monster that waits under the bridge. When you get to the bridge, the troll jumps out and surprises you. If you're a fan of Dora the Explorer, you know what I'm talking about. They're grumpy old trolls. They come out and they say, pay me a price or you can't go through to make your product. And this is, of course, the trouble with NPEs, with patent trolls. They are viewed generally as being a bar to innovation. You are stopping me on my path to innovation because you are making me pay for something, and you're not even competing with me. The trouble is so great, some say, that part of the patent reform that was just passed was targeted at NPEs. And in fact, the General Accounting Office has been tasked with studying the costs and benefits of NPEs in our society. I'm going to talk about why it's not just about trolls. But in order to say that, I need to tell you what trolls are. So, now when I talk about rethinking patent quality, what do I mean? What does it mean to be a quality patent? There are lots of different ways to think about this. One way is to say it's a huge invention. It's important. For example, somebody invented the transistor. William Shockley invented the transistor. He got a patent on it in 1948. Wasn't really used for a long time after that, but that's a pretty important invention. We couldn't do anything we do today without it, electronically speaking, which is just about everything. The problem is it's hard to gauge when a patent is important because there could be very minor inventions that are extremely important, that make people happy, like the Slinky, also patented, like the paperclip, also patented. Is it hugely important? Probably the paperclip, maybe the Slinky. How do I measure patent quality? What am I talking about here? I take a more simple approach. Would the patent be valid if it were litigated? Is the patent novel? Is it new? Were you the first inventor? Was it obvious? Could anybody have thought of this? Is it useful? Do you describe how to make it well enough so that you've taught something to the world? This is what I mean by patent quality. And so when I'm measuring patent quality and I'm talking about thinking about patent quality, that's what I'm talking about. And here's the reason why, in large part. You don't have to pay for a patent that's invalid. There's a rule that says if you try and assert a patent that's invalid, you can actually be held liable for antitrust violations. And so a quality patent is one that you can force people to pay you to use, and a bad patent, a poor quality patent, is one that you can't. And the general view is that patent trolls have poor quality patents, that they do nothing to help innovation, and that all they create is social cost. And what I'm going to talk about now is whether or not that's true. This is based in part on a study I did of the 10 largest patent trolls. I found all of their litigation. It was 1,000 cases. We found all of the patents they asserted in those cases. It was about 350 patents, which means basically patents were sued on multiple times. And then we studied who got those patents in the first place. Was it individuals? Was it small companies? Was it big companies? Where did these patents come from? What was the tie to innovation? What was the tie to investment? And I'll tell you a little bit now about what I found, which was surprising. And this is coming out in an article next month in the Seton Hall Law Review called Patent Troll Myths, because it turns out just about everything we thought about patent trolls is not right. So first, NPEs are not new. A lot of people say these trolls, they've come up out of nowhere in the last 5 years. It was all because business methods were patentable, and I'll talk a little bit about what that means in a little bit. But the idea is the Federal Circuit, which reviews patent laws, has allowed more patents, and now we have lots of patent trolls. And the reality is that's not true. That's not true. Some of the most litigious patent NPEs started 25 or more years ago. This is in the 80s. It's like ancient history. And it turns out that the patents they assert came from productive companies. So, for example, of the business entities that obtained patents, 75% were corporations. If you expected them to be if you expected them to be assertion entities or licensing only, you would probably see more LLCs in this instead of corporations. These aren't the trolls themselves. These are the companies that got the patents in the first place and then assigned them to the trolls. They're the source of the patents. Only 21.5% were licensing entities at the time the patent was issued, meaning we called them trolls, essentially. Only 21%, and even that is saying a little bit too much, because it turns out you have patent families. You file one application, and then you can get multiple patents. And what you'll see is the first 2 patents will go to productive companies, and then the third one will go to the patent troll, because by then the whole family had been assigned. And so it turns out a large portion went to corporations whose business was not to license patents. Their business was to make stuff. 42% of the corporations had 500 employees or more. Big companies were getting these patents that are now being asserted by patent trolls. 20% of them were public companies, traded publicly, and there were even more that were subsidiaries of public companies, privately held companies whose parent company was publicly traded. And about 17.5% of them received venture capital, and venture capitalists typically invest only in companies that are making stuff and selling stuff. So it turns out that NPEs may not be the hamper on innovation that we thought, because they're getting their patents from people who are trying to make stuff, and that's why we have patents in the first place, to get people to invest in making things. So then I looked at the flip side of the coin. If that's true, then maybe NPEs are out there to help people get investment, to enhance venture capital funding. Because what they do is they allow for an aftermarket, a third-party market for making money for failed companies. So let's say I have a startup. I'm trying to woo investors and say, look, give me a couple $1 million so I can make my product. The investor theoretically will say, well, what if you fail? And then the company says, well, I can just license to a patent troll who will monetize it, and you'll get some of your money back. And the VC says, aha, of course that's what I'm going to do. It turns out I'm not sure that's true. Maybe in some cases that's true. But let me tell you why I don't think it's true. And this is one of the defenses of NPEs that I don't think holds up. First of all, I did find that NPE contributors, 17% of them had venture capital funding. And I took data from the Kaufman Firm Survey, which is a panel survey, a longitudinal survey, meaning survey over time of startups from 2004, and it turns out that if one of those companies, a random selection, had patents, 10% of them got venture funding. So on the face of it, it looks like NPE contributors were more likely to get venture funding. What I also found was that less than 1% got venture funding if they didn't have patents. This, to me, leads to a conclusion that having patents is good to get venture financing. No question about it. But is it good? Is it better to have NPEs exist? I think not. Here's why. Number one, the Kaufman Firm Survey looks at startups who started in 2004. The average age of the NPE patent was from 1997. So I assume most of you are familiar with this, but if you are not, it was much easier to get venture capital financing in 1997 than 2004, by leaps and bounds. I was practicing in 1997, or I was about to. I was just graduating, and you could like roll out of bed in the morning and get venture funding. It'd be like, I invented something new to scratch my head. VCs will give you $1 million to run with it, as long as it's on a computer. Not so much in 2004. The other thing I found is that there were very few failed companies in the mix. And that those companies who failed did not have venture capital financing, which is probably why they failed. So in other words, if NPEs are there to create more money for failed companies, if they happen to fail by selling their patents, they're doing a very poor job of it. Because the ones they're funding are the ones who actually succeed, not the ones who fail. So I think the venture funding change here is not based on the existence of NPEs, though I can't rule it in or out. But here is where NPEs do create a lot of benefit. Individuals. In my study, individuals originally got 28% of the patents in the study, and another 14% were individually owned companies, like Katz. He's got a company called Ronald A. Katz Licensing, LLC, where he licenses all the patents he got. That's essentially an individual asserting his own patents through the form of a limited liability company. If you look at all litigation from 2000 and 2002, 14% of the patent plaintiffs were individuals. 14%. And so I think that patent trolls do serve a very valuable role in society by helping individuals assert their patents. And the reason is relatively clear. Individuals need cost money and other kinds of money to litigate. Patent trolls, NPEs, provide that. They do provide an aftermarket for individuals who are not trying to make anything. How you feel about patent trolls will depend on how you feel about individual inventors. If you think the garage inventor motif is really important, then you'll think patent trolls are really important. If you think inventions by individuals are useless, then you will think patent trolls are useless. I don't have an answer to that one, but I do know that the importance is with individuals. So one more point on the macro level, the social cost. This is not measured by me. This was measured by Besson and Moyer in an article that's just now out. What they did was an event study of stock prices. They looked at shares on the date that a complaint was filed against a public company. They did this for NPE lawsuits, and they did this for lawsuits by practicing companies against other practicing companies. And what they found was that the stock price dropped less when a patent troll sued. So, for example, if I'm Microsoft and I'm sued by Apple, my stock price drops by 5%. If I'm Microsoft and I'm sued by a patent troll like Acacia, my stock price drops by 4%. But it turns out NPEs sue larger companies. And so their view is that the market losses are higher because bigger companies have a bigger market capitalization. So even though it's a 4% drop, in absolute dollars, it's a bigger loss. And so they argue that trolls have a greater social cost than other patent parties. My problem with this study, aside from some technical stuff, is it leads to the unpalatable solution that the way to fix the patent troll problem is to convince them to sue smaller companies. And that, to me, that just can't be right. That can't be how we look at this. So now I want to talk about quality on the micro level. I don't really talk about quality on the macro level because there's no real way to measure quality in big chunks, although part of what I'm going to talk about on the second half of this talk is how we might do that. So on the micro level, it depends on your benchmark. Mine is, will the patent hold up in court? And it turns out that in my study of 1,000 cases, 350 patents, only 40 patents were judged on the merits. 4 of them were found valid completely. 23 were found completely invalid, and 19 were found partially valid, which is actually a win for the plaintiff, because as long as you've got one claim left, you can still sue somebody. Now, this adds up to more than 43 because some patents were adjudicated multiple times. So in one case it would be found totally invalid, and in another case it would be found partially invalid. Another way to look at it is if you just look at judgments, 28% of the judgments completely invalidated one or more patents. Compare this to another study of all litigation from 95, 97, and 2000, which found that 20% of judgments invalidated at least one patent. So, based on that, you can say that the troll patents are in fact invalidated more often, but not so much more often that you say, oh my goodness, the inventive society is going to collapse. 28% to 20% is really just not that big a difference. What we do find, though, from a quality point of view, is that it's nearly impossible to win an infringement judgment as a patent troll. They get lots and lots and lots and lots of settlements. Of the 1,000 cases, 950 plus settled. There were 3 infringement judgments in 1,000 cases that we looked at. 3 where damages were actually awarded. There were a couple where there was a default judgment, but we don't count that. So infringement judgments are quite rare. So what I think part of what's happening is judges don't like patent trolls, but the patent troll patents are actually pretty good. So what they do is they narrow them, they construe them to be narrow, and if they're narrow, then they're not infringed. Because I didn't actually invent a pen. What I invented was a black pen with a cap and a particular type of tip. If that's my invention, then it's much easier to not be infringed than if I just say a pen, because there's lots of different kinds of pens. At the micro level, I also want to look at competitive litigation when I say it's not just about trolls anymore. So, for example, recently, for billions of dollars, a consortium led by Microsoft and Apple bought all of the patents of Novell and Nortel, which were 2 early players in technology. The interesting thing about this is there was a post by one of the leading attorneys at Google who talked about Microsoft and Apple. You've probably heard of them. They make stuff. Talking about them as if they were the worst of patent trolls. How could they do this? They're buying these patents from these defunct companies that never made anything good, which is a big lie, of course, and assert them against us. Of course, Google did not disclose that they had bid $2 billion for it and were outbid. So really it was sour grapes. And so Google's response was to buy Motorola Mobility to get some patents themselves and to assert back and forth. Also, we have Apple versus HTC. I don't know if you knew this. If you were trying to buy a cell phone from HTC as a Christmas gift for your friend or family, there was actually a big risk the International Trade Commission was going to bar all imports of HTC phones because they've been found to infringe an Apple patent. Turns out the ITC gave them time to design a round, which is very rare. But just ask HTC, who makes Android phones, whether or not it's patent trolls they're going to be worrying about. They're worrying about Apple. These are big players who are suing each other. And the thing I like to come back to on this is that you know a patent troll will always take some amount of money for a license. You can avoid a suit. You may not like how much you're paying, but you can avoid a suit because they want money. That's what they're in business for. The same might not be true for competitors, because your competitor might want you out of business. $1 million, a $2 million, a $5 million license is nothing compared to the billions of dollars you can obtain if you drive your competitors out of business. Last point, risk of suit. This is my colleague at Santa Clara, Colleen Chen, just published an article about predicting when you're going to be sued. She found that the greatest determinant of whether a patent will be litigated is whether the maintenance fees are paid. You have to pay maintenance fees 3 times during the life of a patent. Well, it turns out if you don't pay the fees, you can't sue on the patent. So she found that basically, if you want to know if you're going to get sued, look and see whether or not the fees were paid. She also found that assignment was also a determinant, but here's the key part about it not being about trolls anymore. It doesn't matter who it was assigned to. The key is that it was assigned to somebody after it issued. If it was, then it's more likely to be sued on. Well, that makes sense, doesn't it? If I'm not going to do it and I assign it to somebody, then that somebody's buying the patent to do something with it. Final point on patent quality, even large companies get ridiculous patents. The latest one I like to talk about is slide to unlock. If you own an iPhone or an iPod and you go like this to unlock your phone, yeah, that's patented now. And in fact, Apple has sued Samsung, claiming that Samsung is infringing because of their slide to unlock, which to me is ridiculous for a variety of reasons. So, if it's not about trolls, then what is it about when we're talking about patent quality? I like to look at the patent portfolio. So imagine that there's a patent plaintiff with multiple patents, 100, 200, 500, 1,000. There are some patent trolls that have 30,000 patents. You know that some of them are probably valid. You know that some are probably invalid. And some you don't know about. Some you don't know about. But let's say there's 100 patents and only 2% are valid. 2 patents, that's enough to pay $1 million or $2 million or even $500 million in damages. So the goal should be to accurately price the portfolio. Because if you don't price the portfolio accurately, then the ones that are questionable will be litigated. You'll be bickering about patents that may or may not be valid, when in fact you are better off just paying one-time fee for the whole thing. And in this sense, patent aggregators, like patent trolls, may be more efficient because they can come to a party and say, I've got 1,000 patents, we've looked at them, we think you're infringing at least 5, 10, 15, 20 of them, and that's enough that you should pay us. But when you have an individual or a small patent troll that holds 1 or 2 patents, that's their baby. That's that's the one horse in the horse race. It's the one bet. It's the lottery ticket. And so they are going to require a micro view. They're going to require patent-by-patent negotiation. It's inefficient. It increases the likelihood of litigation. It's unlikely when you have a portfolio. It's unlikely because nobody's going to sue you on 5,000 patents. Can you imagine a lawsuit where they say, I have 5,000 patents and you infringe every one of them? Go figure it out, court. No judge is going to allow that. Additionally, the AIA, the American Invents Act, which is a very interesting title for this patent reform, limits cases to 1 defendant per case. So now I've got 5,000 patents, and I've got to sue one party here, and another party in another case, and another party in another case, which is also arguably very inefficient when you have a big portfolio. And so it's better to just figure out how to measure quality and price the whole portfolio. I don't have an answer to that question, by the way. That's maybe the next paper. That's the hard question. There are actually companies who have patents on a portfolio pricing strategy. Ocean Tomo has one. I got an email from a guy who wrote his dissertation on valuing patent portfolios. I haven't read it yet. We'll see how well he does with it. So here are some ways to measure patent quality. One way is in-depth study, prior art searching, crowdsourcing. There's a company called Article 1 Partners. They put up a patent and offer a bounty, $5,000 to whoever can find prior art that invalidates that patent. Works pretty well, but it's probably inefficient for large numbers of patents. It doesn't really work. The other problem we have is objective indicia of patent quality fail. What do I mean by that? For years, economists have measured patent quality by saying, let's look at how many citations it has. Let's look at how many claims it has. Let's look how long it sat in the patent office. And they say that more of this means the patent must be better. But it turns out if you measure against whether or not they win in court, it doesn't work. Those measures don't work. So maybe we have to do it on the smaller level. Maybe we can't look at the whole portfolio. Maybe you need pre-litigation assessment, joint efforts. Both sides to the negotiation work to figure out the value. Maybe you have a baseball negotiation, kind of like a baseball arbitration. You say, I'll pay you $1 million if these certain things happen, and the other person says, I'll pay you, $5,000 if they don't. And then That's the number. You're not arguing about price, and you pick something objective you can measure. Another way to deal with it is cross-licensing. This is what big companies do. IBM has 3,000 patents in this area. A competitor, Microsoft, let's say, has 2,000. What they do is they say, let's measure how big my stack is. They'll literally like print them out and say, well, mine's this big and yours is this big, so you owe me a little bit of extra money, or just throw in a couple extra patents. It's not really based on patent quality. It's not even sometimes based on the technology. They just count them up. Furthermore, pre-litigation quality assumes the desire to settle. But if exclusion is the goal for competitive litigation, then any pre-litigation activity is unlikely to be helpful. So now, how do we look at quality once we're in litigation? That's a little bit easier, because once you're in litigation, you're only being faced with a couple or three patents. So one way to go is prior art searching, crowdsourcing. You give your patent to Article I partners and you say, find me prior art. The problem is, this is also hard because it's very difficult to have early determinations in patent law. The big issue is claim construction. Claim construction is where the judge determines what the patent actually means. And people argue over words like is. If you're familiar with Bill Clinton's trials and travails, you know that people joke about the meaning of a single word. Well, guess what? In patent law, people argue about the, is, there. They argue about plurals. They argue whether one means one or more. And the problem is you're well into litigation before you get that answer. And often the entire litigation turns on that answer. So all of the pre-litigation activity doesn't work. Additionally, for broad patents, we have what are called enablement description problems. In other words, you're claiming the world, but you only told me how to make one thing. We're probably going to talk about this a little bit when we get to the gene patenting issue. You're claiming every pen ever made, but you only told me how to make this one. That's not fair. Additionally, if you're an individual plaintiff or a small patent troll, you may overvalue individual patents because it's your baby. You've got to get a lot of money. I talked to a lawyer from Microsoft. He says every demand letter they get thinks their patent is worth $500 million. Every single one of them. But that can't be right. That can't be right. So it makes you wonder, why don't more defendants litigate to judgment? Because as I showed you the numbers, defendants win most of the time. And the answer, of course, is when it is worth $500 million, you don't want to be the guy or gal who said, let's take this to trial. Let's take this to trial, because that can be pretty costly, including your job. And so you wind up with this weird negotiation that fails to integrate these four dimensions. So I'm way over time, I know here, but I've got just one more kind of comment about all of these. We've got the micro level and the macro level, the society level and the individual patent. And we've got the trolls versus the non-trolls competitive litigation. I think that the best way to manage things is to figure out, to rethink patent quality, to decide how it is we can measure patents cheaply and easily. And I don't know the answer to this. I don't know if it's having more crowdsourcing, because when there's 100,000 people searching, then searching on 5,000 patents is easy. I don't know if it's figuring out some better measures on the face of the patent that allow you to figure out what the patent price is. I think it is conglomerating patents into one big group and then pricing them. But figuring out how to do that, that's the heavy lifting. And it's heavy lifting that not a lot of people talk about, because they prefer to either say trolls are bad, so they harm society and innovation, or they like to look at, that's the macro level. On the micro level, they like to say, this patent's invalid, that one's valid, this one's invalid. But both of those don't really move the ball forward. It would be better to figure out some way to combine the two and measure things on the whole. So thank you. Hopefully there are some questions. Hopefully not, actually. Maybe I was so clear that there are no questions whatsoever. Okay.
Thank you, Michael. It's a very interesting talk. I know nothing about this, but it's quite interesting. Here's my question. I gather that in this patent troll litigation, right, that if a lot of these things are not litigated all the way through, presumably an awful lot of demand letters are starting settlement processes, and then some kind of settlement is reached in which some kind of licensing fee is ultimately paid, right? And so I could imagine somebody saying, well, isn't the answer that then, you know, the outcomes of all of these settlement negotiations about how much the licensing fee should be is basically determining what the market thinks the patents are worth, and why isn't that sort of the de facto determination of patent quality?
That's true in large part. That's true in large part because I looked at 1,000 litigations, 950 settled. There may have been 10,000 other ones that never got to litigation. And so when people say, even when they say the patents that are litigated by trolls are all bad patents, even if that were true, well, you would expect the questionable patents to be the ones that get litigated. Maybe the bad ones if they're overvalued. The problem is none of that negotiation is public, and patent damages, I didn't get a chance to mention this, but patent damages will lead people to their negotiation on what the royalty should be for a license. And so if patent damages are not measured properly, then you have a problem with negotiation. So the answer is the market should help figure out, and it does do a lot of the sorting. But there's a lot of times where there's holdup and overvaluing, and if you had good patent measurements and you had good public data about what licenses were going for, then it would be helpful. So one thing I'm working on with some of the largest patent trolls is, in fact, figuring out a way to get some of that data, but anonymously, so you can create an info base of patent licensing so that the negotiations might be run a little bit smoother.
Maybe one more question?
Yes, oh, two more maybe. Go ahead.
I just want to give you a corporate perspective. I've worked on some of these, involved in some of the settlements, and these involve like barcoding patents, both the linear barcode and the new square barcode, and they have such scope.
Right.
They're in such great use that the patent trolls can go after hundreds of thousands of defendants, and therefore they can adjust their settlement numbers to very reasonable levels. And when you're faced with going into a patent litigation where you may have to anticipate spending $2 or $3 million to litigate this case, and the troll says, I'll license you this for $75,000, your decision is basically made.
Right.
Just to show up, you're in the $1 million range.
Right.
So, and then the patent troll moves on to somebody else. And also you have the factor with being a public company and with this threat cloud hanging over your head, where you may not be able to distribute products. Who knows, you could go to some judge and get a preliminary injunction and not be able to ship any product to the barcode. It's unlikely to happen, but it's a threat, and a public company
It's high risk.
doesn't want to do it.
It's very high risk. So 75 grand doesn't sound so bad, right? So
Business decision more than a legal decision.
I think that's right. And the other thing that's interesting when you say it, there are so many of these. So the idea is if you're seeing so many of them, you actually kind of get a feel for which ones might be worth fighting and which ones not. And you wind up almost with a market, because then when somebody comes in and says, pay me $150, you say, we've seen 10 of you like this, 75 is the going rate. It actually can make it easier to settle. Now, maybe they're all overpaid. I don't know. Somebody's got to, somebody would have to take them on. But that's a great perspective.
Yes, I was just wondering what your response would be to the argument that these larger companies like Microsoft and Apple are perhaps buying up these patent troll companies in order to prevent from being sued as opposed to suing.
They are doing some of that. And there are some companies whose business model is to find patents and use them to block, so basically buy them first. in other words. So yeah, some will do that, but that will only protect against competitors. The reason that practicing companies pull their hair out with NPEs is there's no chance at a cross-license. The cross-license is the holy grail of industry. I have patents, you have patents, let's make friends, let's have detente, I won't sue you, you won't sue me. We're seeing that break down with the smartphone wars, with all the smartphone manufacturers suing each other. But by and large, that worked. So the purchasing of patents, like the reason Google bought Motorola Mobility was not because they were worried about patent trolls. They were worried about competitors. So patent trolls might be licensed. The problem is it's not really if it's not an exclusive license, if it's not a purchase of the patent outright, then they can't use it in defense. So they actually have to buy up the whole thing. Some companies do that. Some companies do that.
Thanks.
Okay, thank you.
Thank you so much. So today we're going to move on to a panel. We have a great panel today to discuss gene patents and the role they play in society. Again, I'd like to take credit for this, but really this work was done, again, by Zachary Kennard. He put together this really great panel. Just to give everybody a frame of reference, patentability of genes and the scope of patentable subject matter has really been the source of intense review lately. Supreme Court's decisions such as Bilski dealing with business method patents, Prometheus dealing with personalized medicine and diagnostic methods, which are currently under review by the Supreme Court, and the Myriad Genetics case, which we're going to talk to you about today, is currently undergoing certiorari. These are just a few cases that may guide the biotechnology industry in the very near future and for years to come. So we're going to start with Professor Obringer, who is an assistant professor in the Department of Obstetrics and Gynecology at the WVU School of Medicine. She has an MS from the University of Michigan and a PhD from the University of Pittsburgh in human genetics. She'll briefly give us a background on the science behind genetic testing and how practitioners actually use this information to diagnose patients. Next, we have Mr. Steve Flynn from Mylan Pharmaceuticals. Mr. Flynn is the Associate General Counsel for Mylan and is responsible for the company's global intellectual property matters. He's worked with several giants in the pharmaceutical industry, such as Wyeth Pharmaceuticals and Whitehall Robbins Healthcare. He has a BA from Hamilton College and JD from NYU Law. Mr. Flynn is going to talk about how industry reacts to commercialization of gene patents. And finally, we have Professor Risch, who will kind of discuss the legal framework with which these companies and diagnosticians will have to work in and pose some of the interesting policy and legal questions that arise from these cases. So if the panelists would join me up here, I might start. Yeah.
Are you? Oh, there you are. Is that you?
That's me.
Beautiful.
That's me. Well, thank you, Professor Tu, and thank you, Mr. Kennard, for inviting me to come today. This is a challenge for me after listening to Professor Risch. I can understand why you might not know quite as much about science as I do, and that's why you do what you do and what I do what I do. I'm going to talk a little bit today about BRCA 1 and 2 and give you a little background. And I thought I'd really start at the beginning. Which way does it? Which one? This side? Okay. All right. So I'm going to start at the beginning, or at least as close to the beginning as I can get. And this just gives you an overview of what we are talking about. Every cell in our body has 46 chromosomes. and they are in the nucleus of the cell. The chromosomes are actually tight-knit strands of DNA, which are in double helix form. I'm sure that you all know about that. And the DNA, the coding, sorry, I can't remember. The adenine, guanine, thymine, cytosine, the four base pairs, are what is used to give the information to produce the proteins. And BRCA1 and BRCA2 are proteins that are in every cell in our body. Okay. How do we get from the DNA to the protein? And certainly you have a DNA sequence such as this, and if you have any change in a base pair, then you might end up with a defective protein. So you can go, if person 1 has an A in the third position, person 2 has A in the T in the third position, and person 3 has a C, you know, in person 2, you might end up having a functioning but low functioning protein, but it'll be produced. But person 3 will have an abnormal protein produced in this scheme. And then if you look at the various codons, which are 3 triplets of these base pairs, they produce the amino acids. So, and the amino acids are the foundation of proteins. So again, if you look at person 1 and person 2 and person 3, you can see that certainly a person 1 who has the normal genes and the normal codons, the protein product will be fine. Person 2 may or may not be fine. Person 3 probably will have a defective protein. And this scheme might be a little bit easier for you to understand, at least in terms of the types of mutations that we talk about. And that's important because, particularly in this case for BRCA1 and 2, there are different types of mutations. And so you will hear or see or read about all of these various types. If you look at that sentence, you can see Sam and Tom ate the ham. Well, if you have a frame shift, it just means things moved over one in that particular case. And you can see how it made a nonsense sentence. If it's a stop codon, if the mutation or change in the genetic material is a stop codon, then it just stops after the subject. You can also have missense mutations where you end up having a substitution that produces a word that isn't the same as the original word. And then there's also a splicing mutation in messenger RNA, and it just takes out the whole middle of it. So that's essentially what they are looking at when they look at the different mutations in the BRCA1 and 2 gene, and what they are looking for when they try and diagnose whether someone is a carrier for BRCA1 or 2. BRCA1 was first identified in 1990 by Mary Claire King, who used a methodology called linkage analysis. So she looked at actually DNA from families where there was looked like inherited breast cancer, and that's how she found the gene which was associated with breast cancer. And it was located on chromosome 17q. In 1994, Stratton, Worcester, and Hingston isolated the BRCA2 gene. They were in England. They worked together, they collaborated, and identified the gene BRCA2. That same year, BRCA1 was sequenced, And then in 1995, BRCA2 was also sequenced. When they started working with these genes, they noted that they were tumor suppressor genes, which means that in the normal case, without any mutations, they act to protect the cells, and you have normal cells being produced. If there's a mutation in that tumor suppressor gene, then you end up having the cells rapidly dividing and causing the development of cancer. So that's what both of these genes do. And as you can see from this diagram, they're two different genes. They're located on two different chromosomes. BRCA2 is on 13q, but they produce both breast and ovarian cancer. So that's something to remember. So you can have either BRCA1 or BRCA2. They are what we call germline mutations, which means that they are inherited from one generation to the next. So that the genes themselves actually don't cause cancer, they predispose somebody to develop cancer. And that is variable depending on the family, depending on the mutation. It's also important in terms of the prognosis, because the prognosis will depend on the type of mutation and actually when it was diagnosed. So it is estimated that 1 in 400 to 1 in 800 individuals carry BRCA1 or BRCA2. But one thing to remember is that these two genes account for only 5 to 10% of all breast cancer. Most breast cancer is sporadic. So you're looking at a very small group of people who may have BRCA1 or BRCA2. You may see families that have breast cancer, but don't necessarily have BRCA1 and 2. BRCA1 and 2 are the only two genes that are known to cause breast cancer. Most are sporadic or familial. So if we look at the hereditary breast and ovarian cancer, BRCA1 and 2 are the most common causes. They occur in all ethnic groups and racial populations. Certain ethnic groups have specific mutations that occur more frequently in that group of people. For the Ashkenazi Jewish community, for example, there are 3 mutations that are known to occur most frequently. And these are called founder mutations because they have come down from generation to generation to generation. They've also identified 3 mutations in BRCA1 in the Dutch heritage, and a BRCA2 mutation in Iceland. And you can look at other ethnic groups or countries of origin, ancestry, and you will usually find a specific mutation that might be in that characteristic of that particular ancestry. So BRCA1 is located on chromosome 17q. It has 24 coding exons, so it's 80 kilobases. So it's a very large gene. And the exons are the part that actually transmit the information to the RNA. There are other parts of the gene that don't provide that function. They're called introns. And there are other areas of the gene that may have some significance in terms of how the genes are manifest. There are over 1,600 mutations that have been identified in BRCA1, and most are frame shift mutations, and lead to non-functioning proteins or missing proteins. If one has a copy of BRCA1, they are much more likely to develop breast or ovarian cancer during their lifetime. The risk for breast and ovarian cancer in any woman increases as you get older. But if you have the BRCA1 or 2 gene, then that risk becomes very high, so that by the time one reaches 80 years of age, the chances of someone with BRCA1 or 2 having developed breast cancer is almost 90%. It also occurs earlier in the population, so that someone who is 35 who develops breast cancer may be more likely to have one of these genes. And we'll talk a little bit more about that in a minute. BRCA2 on 13q is very similar, and the work that these genes do within the cell are sort of housekeeping genes. As long as they are not mutated, they just keep the integrity of the cell and the genetic information together. And here's just a schematic showing the types of mutations and the numbers along the length of the gene for both BRCA1 and BRCA2. And you can see that most of them are frame shift mutations. You have a few missense mutations, and you have some splice mutations. So when we do testing for BRCA1 and 2, someone will come and say, I have a family history of breast cancer, what's my risk? And we can use it to the testing to look at the genes to see whether or not an individual does have the gene, and that can be done prior to developing symptoms, or oftentimes women who do develop breast cancer, have been diagnosed with breast cancer, will have testing to see whether or not they are carrying the gene. And so they might do whole gene sequencing. In some individuals, particularly, let's say the Ashkenazi Jewish population, if you have ancestry that's Jewish, they may only do targeted mutations because of the 3 that are most frequent and can be easily identified. And now they have something called large rearrangement testing, because they've found that there has been disruption of the sequencing, and it's been totally rearranged, moving, just sort of inserting and deleting and reinserting. And that is now being used as well as part of the clinical testing for the presence of a breast cancer gene. Now, who should get this testing? And this is one of the more important things that you need to know. The earlier age of onset, under 50 years of age, for breast cancer, is one of the criteria. It's probably the primary criteria. Most women who don't have the gene usually don't develop breast cancer until they're in their late 50s or 60s. If an individual has had 2 breast primaries, so that having both of their breasts affected, that would be bilateral breast cancer. That would be another reason to have diagnosis done. Or if they've had breast cancer and ovarian cancer, or a peritoneal cancer that probably is related to the ovarian cancer. If they are Ashkenazi Jews, members of a family who have a mutation in that family and want to be tested. If you have an aunt who has breast cancer and you want to know what your risk is, I mean, that is a legitimate reason to have testing done. Any male in the family who has had breast cancer, That would also be a red flag to have cancer testing for BRCA1 and 2. And then ovarian cancer at any age is also a criteria for getting to be tested. And when the testing is done, it's done in stages. You have a pre-test where you talk about the counseling, making sure you have a risk that is acceptable to have the testing done to see if you have the gene. And you do that by looking at the family and medical history. If the risk, based on looking at all of these mutation probability models, gives you a risk of greater than 10% of having the gene, then you should have the testing done. And that's usually what is recommended. But people make their own decisions. So some people will have it done, some people will not have it done. But you have to have an informed consent, and then they will do the testing, which means that we send the blood to Myriad Genetics. And then they send us the results back, telling us whether or not there is a mutation present that they can identify. And if there is, obviously you sit down and talk to the patient again about what needs to be done clinically for that individual. If it is not, then you still have to sit and talk to them and make people realize, even if you don't have the gene, you still are at risk maybe at risk for developing breast cancer. So it is a formal process, and it's very important to do both pre and post testing. So here we have a gene with some base pairs along the gene, and this is what we could say that this is the BRCA1 gene, and this is what is being patented. There are gene patents out there, and it's usually on a specific isolated gene sequence, looking at its chemical composition, the process for obtaining or using it, or a combination of both. Patents have only been granted on isolated gene sequences with known functions, like the gene for cystic fibrosis. Patents cannot be applied to the naturally occurring genes in humans or other naturally occurring organisms. However, if it is made up of DNA and it is in your cells, then, I mean, to me, it's in the organism. But about 20% of human genes have already been patented, so I don't know. I guess that's part of what we're going to discuss today. So just a little bit about Myriad Genetics. It was when the BRCA1 gene was sequenced in 1994, one of the individuals who was a founder of Myriad was one of the co-workers who worked on the gene, and his collaborators at the University of Utah. NIH was involved, McGill was involved. But Myriad had already become a company. And then through buyouts and acquisitions, by 1999, Myriad was the only company that was offering a test for and doing research on BRCA1 and 2. Myriad has 8 commercial molecular diagnostic products. They do testing for colon cancer, skin cancer, and cancer of the pancreas. And then they have also 4 personalized medicine products as well. So they're very involved with genetic testing and patient care as well. And the question is, the case that is up before the Supreme Court, if it ever gets there, but has been around now for a couple of years, Myriad, the case itself involves the patentability of the isolated DNA. And as I was telling Zach, what I've read is it's not quite as simple as that. And so I can understand why there's a lot of different opinions about it. Myriad holds the patents on 2 isolated genes, BRCA1 and 2, which are linked to the susceptibility of breast cancer and may be used for clinical screening. It also holds the exclusive rights to the sequence and mutations along the gene, patents on methods for locating the mutations, and correlations between the mutations in breast and ovarian cancer. However, not all the patents that Myriad has are involved in this litigation. There are only 7 out of the 23 that they have. Whoops. I'm sorry. So obviously, the plaintiffs, who are a large group of people who brought the case against Myriad, and involve organizations such as the American College of Medical Genetics and molecular pathology, there are a whole slew of individuals who have brought or companies or organizations who have brought suit against Myriad. One of the concerns is that the presence of the patents prevents patients from getting second opinions, because the only opinion that they're ever going to get is from Myriad, because they're the only ones that have the patent to the gene. So that's one of the questions. And then it also doesn't give providers the opportunity to select where they want the testing done, because Myriad's the only place that does the testing. So those are the basic concerns. The President's Committee on Human Genetics and Human Genetic Services wrote in 2010 that most genes are discovered in the context of academic science, where scientific exploration, publishing, and recognition are the primary motivators for researchers. Patenting is not necessary to spur innovation and research. Once a gene has been identified, the development costs for genetic testing is very low, and hence patenting is not generally necessary for commercialization of useful gene tests. So that's the President's Commission. So for right now, that's all that I will say. So if you have any questions, I'll be happy to answer them.
I think we're going to hold our questions until the end, and then we'll go through all of the panelists first. Mr. Flynn?
Just forget it.
No, it's not.
Hi, good afternoon. My name's Steve Flynn. I'm with Mylan Pharmaceuticals down here in Morgantown. I'm in charge of their global IP department, patents, trademarks, copyrights. Before I go on, I just want to introduce some of my colleagues that attended today. Lisa Pessa at the end, she runs our U.S. group. Ann Summerfield in the middle is a U.S. patent attorney. Kathy Prody in the green like Ann, is a PhD. Kathy does our biotech and biosimilar work right now for Mylan. Before I jump in, let me also put in a good pitch. Mylan's a great company. You're in law school. We got a great patent department here. If you're interested in interning, patent careers, talk to us. We're down the block, okay? I had one slide today that I was going to center this whole talk on, and it's sitting right in the middle of my desk right now. So You have to bear with me. This is how I used to perform in law school, so I'm back here right now. But anyway, my understanding of what we're going to talk about today was this case, which conceptually allows for the patenting of genes, okay? And actually, before I go on, let me just issue the disclaimer that you will all understand here. These are my personal opinions. They don't reflect those of Mylan or any of its subsidiaries or affiliates worldwide, whatever, okay? Anyway, there was this case that Myriad tried to patent this gene. The trial court said, no, the gene is just a product of nature. It's a naturally occurring substance. You can't patent it, okay? It went up to the CAFC, the Court of Appeals for the Federal Circuit. My own personal opinion is they've never seen a patent they don't love, which is a problem for us generic companies. But anyway, they reversed the trial court. They found that many of the claims were valid, okay? And my personal opinion is that they were correct on many of those, okay? The fact is that some of the claims were directed to complementary DNA, which are genes that are taken from your chromosome. Some inactive portions are excised, put together. So what they're patenting is a product that doesn't exist in nature. It's a man-made product, and therefore it should be patentable. There were some method claims that they found non-patentable because they related to mental steps. There wasn't any transformation there. It was basically you take this person's gene, you compare it to this gene, and see if there's a problem. And the only real method there is the mental step of comparing the two. And that's, based on old case law, is not a patentable method of thinking, okay? Hopefully that goes on with some regularity in the past. Before I go, and now let me tell you a little about the background of this case. It's been mentioned before that the gene was actually identified by a consortium of people back in, I think I heard 1990.
Yeah.
Okay.
Yeah. University at Berkeley.
Right.
University.
And then one of the people working on this project went off, patented the gene. The gene was later sequenced, and this person, again, filed the application for the gene, okay? So that's the basic setup, and to an IP attorney on the generic side, it smells right away, you know? There's some sort of inequity involved here. But let me step back now to a little about my background. I have biology background, but when I went to school, biology was cats, dogs, and fruit flies. So this is a little advanced for me. So I'm going to go back to small molecules right now. And I had a slide I was going to bring today of a molecule, a drug called albuterol. This is a drug that's given for COPD and asthma. It's been marketed under various names, salbuterol. It was actually put on the market in 1968. It's an old drug. If you bought product anytime since 1968, it's got a patient information thing in it that actually, sets out the structure of the drug. And right in the middle of that formula, there's a ring and carbons, a nitrogen, a couple oxygens. It's still a relatively small molecule compared to what we're here today. There's one atom in the middle that has what they call chiral qualities, okay? And I don't know if any of you took chemistry, but it's a very simple rule that if you have a carbon atom, which has 4 bonds, if each one of the things that's attached to that carbon is different, okay, because of the way carbon will form with those 4 bonds, that carbon will be an optically sensitive center, okay? So you can arrange those four molecules around, or those four chains around the carbon so that you'll wind up with two different molecules. There's two possibilities that you can arrange these four substituents around the carbon. So what you have is you come up with two different drugs that have the same makeup, same number of atoms and everything, but they're mirror images of one another, just like your hands, okay? You've 5 fingers, 4 fingers, a thumb, yet you can't superimpose them, okay? They're mirror images of one another. Same thing happens with these drugs, okay? And based on this easy rule, I mean, you could, if you had somebody sketch out a molecule, you could have and teach a kindergartner the rule. He could go along each molecule and point to that chiral center, okay? Again, this molecule was patented in 1960, or actually before 1968. It was put on the market in 1968. Mylan, my company, recently involved in a case just reported last week where we were sued for putting out one of those mirror images, okay? One should be able to look at that original molecule from 1968. The kindergartner can point out that chiral center, say, okay, I got 2 options. One looks like this, one looks like this. That's, you know, if a kindergartner can find it, it should be fine, or should be, you know, a PhD chemist should be able to locate it, okay? And this is, again, this thing was on the market in 1968. This later patent we were sued on was filed in the 1990s, so it had been out there for 30 years. This was no surprise to anybody that this molecule existed, okay? One of these 2 forms existed. Actually, they both existed, okay? I'll tell you about that case in a minute, but now we look at the genetic case, okay? I think that we have to look at this genetic patent situation at 2 levels, okay? I think we have to, and we can't confuse them. I think we have to look at the actual case, see the facts, see the decision, and rationalize, is that right or wrong? And then we have to look at the broader policy questions surrounding this whole area, you know? And we have to decide if the judiciary should be entrusted with making these decisions, okay? Because that's really where it is right now. You know, if you go back to the facts of this case, you have a group that isolated this gene. They said, here it is. Here's one end of it. Here's the other end of it, okay? An individual then took that aside, used normal, everyday, well-known technology to figure out all the ATCGs in it and sequenced it, okay? That person was then awarded a patent for being the inventor of that patent, okay? To me, that flies in the face of U.S. inventorship law, because the actual identification of the gene, I think, is the invention. Putting it through using well-known prior art methods to figure out the numbers and letters or whatever is not an invention. If I invented a chemical and I give it to my lab tech and I say, you know, take this back to the lab, tell me what the melting point, the boiling point, you know, tell me all the physical qualities of this thing. Put it on stability for 4 months and tell me, does it degrade? My lab tech is not an inventor of that chemical, okay? So anyway, I think we have a situation here where the court didn't look at the facts. I think they got caught up in the fact that they were considering our genes patentable without looking at the facts in front of them, okay? And I think that they went off on a tangent and they said, yes, I'm considering this broader question, which really wasn't supported by the facts before them, okay? that brings us now back to the other issues, the policy issues. And, I'll give you just some random thoughts. I mean, genetic code doesn't change that much. I mean, you read all the time in the paper about comparing somebody's DNA to Neanderthal DNA and all. I mean, we're stuck with it. It's around for a long time. There's not a lot of changes. This is really like the Rosetta Stone for the human race right now, and a lot relies on it. And we're being asked to entrust portions of it to individuals for, finite patent terms, and I just think it's outrageous. The U.S. is also one of the few countries in the world that doesn't have a statutory research exception to patent infringement. So under our U.S. law, if you make, use, or sell or import a compound in the U.S. while a patent's in place and you don't have a license, you're infringing. Other countries have research exceptions that allow universities and all to do their research. Not the U.S. There is a case law exception under the Merck v. Integra case under 35 U.S.C. 271E, which will allow you to do things if you're pursuing FDA, generation of FDA materials or materials that may be submitted to FDA to apply for drug permission. But there is no formal research exception. So I think we're in a dangerous area. There's also the question of use of public money. A lot of this research, in fact, a lot of the sequencing that this individual did who patented this gene, $5 million came from the federal government, and what do we get out of that? There was a case in Australia last year where the government of Australia funded a company do some genetic research. They came out with a test, and the test cost, $43,000 or something to do on some obscure disease, and it made the papers because some family couldn't afford to have their child tested for it. And finally, the government of Australia said, no more patents on genes, and maybe we have to go there. Going back to my albuterol case, again, molecule was there, 1968. It was obvious there were two forms of the molecule just from the structure, okay? We went to the court. It's obvious, and actually, if somebody skilled in the art looks at this formula, it's more than obvious. It's actually anticipated. A skilled PhD should be able to look at that, say, look at that atom in the middle. There are two forms. One is this, one is that. It should be second nature, okay? Our case came back. We lost, awarded $18 million in damages against us, okay? That's what we're facing now. We're entrusting the judicial system with things that they should not be entrusted with right now. You're going to get some bad decisions, and you've got, albuterol, that's fine. That's one situation. $18 million is not going to be the end of the world. But if you're going to trust somebody with, the blueprint of our genetic code, that's a different story. And I think that this has to go out of the courts now. Congress has to take a stand on it and determine what are they going to do with it. A lot of this is publicly funded. It's got to move, we have to have some congressional position on that, maybe we have a research exception. Maybe we have a situation where patents are granted, but any license royalties, are very small or something, or capped. We need somebody to take a position, and it's not for the patent system to determine what's patentable and this whole thing operate under normal patent rules, and it's not for the courts to go ahead like this.
Thank you. Okay, so despite the fact that I have written an article called Everything is Patentable, Mr. Flynn may be shocked to hear that I agree with him on most points. On most points. The basic stance I take in that article is that gene patents should be patentable if they're patentable. And so you have to look at the patentability features. You have to look, is it novel? Is it obvious? Is it useful? Did you invent it yourself? And so the way I look at gene patenting then is that if you create something that is wholly novel, like cDNA, complementary DNA, well, that is artificial, made by humans, there you go. If you're talking about something like a genetic sequence, you have to look at, is it novel? This, I think, is actually hard from a policy point of view because in many ways the gene sequence is just information. And so you're patenting information, but there's all sorts of other information that we don't patent. Music is information. We don't patent it. Books are information. We don't allow patents. So it has to be tied to the usefulness of the information in a way. So it's got to be the actual thing and not the information. And then moving on to things like obviousness. I agree today, well, I think today it's harder anyway because gene sequence, most of the genome has been sequenced. The sequencing technology was very different back in the 1990s than it is today. How different, I don't know. Maybe it was obvious to sequence it at the time. If it was, there should be no patent. And by obvious, I mean, was it just brute force, or was there some creativity involved? I don't know the answer to that. I don't know that the question's being asked, in part because I think you're right. The court focused on, are genes patentable? And the answer was yes. They said this structure, the structure of the gene is different than what's in the body, and therefore it's patentable. So the question of obvious is not being asked about on a case-by-case basis. That said, even though I generally agree, and I don't know how this particular case should come out, I do want to address a few things policy-wise. Number one, the idea that 20% of the genome is patented is actually a myth. There was a Science article that said this a while ago, and it's been repeated often. As we heard today, my colleague at UMKC is working on our article. It's not published yet, so if you might not have known it was a myth yet. But anyway, he actually has pulled every patent dealing with the human genome and looked at it, and he categorizes what's actually been patented and what hasn't. And what he finds is there's lots of patents that mention genes and are related to them, but the actual gene sequences, it's a much lower percentage. And so I'll toot his horn a little. I don't know the exact number because I haven't read a draft of his paper, but he's written about that. A couple other points. In the story here, we heard about somebody identified the relationship, and that was the invention. I totally agree. So I don't know about the history, but I agree that the facts of that history should be viewed. But what's interesting is when we look at natural correlation type methods that people don't like, oftentimes people don't want to give patents to the people who figure out that correlation. So, for example, there was a case that went to the Supreme Court. It was dismissed without an opinion for a variety of reasons, where some researchers had discovered that if you had high levels of homocysteines in the blood, then you had a vitamin B12, basically a folate deficiency. And they got a patent, and it was a simple patent with mental steps. Measure homocysteines. If they're high, diagnose a disease. On the one hand, this is such a deceptively simple method. How crazy is it that we should allow a patent on human thought and correlation? On the other hand, they figured this out and nobody else did. So why wouldn't we give them a patent? They spent time, money, maybe the governments, we'll talk about that in a second, and effort to figure out something that nobody else did. And if we had a machine where you could go like this and diagnose a deficiency, we'd patent it. If we had perhaps a device where you peed on it and it told you if you were pregnant, we might allow a patent on that because it's a thing. So the idea that it's a thing that does the correlation instead of a mind seems to me to make little difference. And so the method patents here with the BRCA gene, it's deceptively simple to say, well, there's no transformation, therefore there should be no patent on this method. But the method is only obvious if finding the gene was obvious. If it wasn't, then it shouldn't be. But then again, if the person who sequenced it is not the person who discovered the correlation, maybe they shouldn't get the patent. I don't know. Another point in the story, Myriad consolidated its power through acquisitions and buyouts. That means other people were doing research in this area, other people were getting related technology patents, and they bought it out. That is what patents are for. Invest so that people will spend money to commercialize. Now, we don't like the results that all this power is conglomerated, but that's an antitrust problem. If we don't like that there's only one source, then we have an antitrust problem. But there's lots of things that are patented where there's only one source, and you live with it. For example, TiVo has the trick play patents. There was only one source. They wound up suing, making lots of money, getting licenses, etc. It happens with patents when you invent stuff. So saying genes are different, they are a little bit because there's health involved. But this is what the patent system does. Now, it may be from a policy level, we say we can't have that. We just cannot have that. I'm not convinced yet because if you want your genes tested, you send them to Myriad and they will do it. There are other genes, actually, from a study where they were not accessible and you couldn't do any research. And that leads to the next point. I agree there should be a research exception. I think it's shameful we don't have a research exception in this country where other professors, genetics professors, can study and find out more because there happens to be a patent. But related to that, let me talk finally about the fact that it was academics who did this. The Bayh-Dole Act says that even when the government funds something, the university owns it because the idea is the university is in a better position to commercialize it. And it's not like this is a new thing. This is 40 years ago this act was passed. 40 years ago. I'm working on a study right now where we gathered all 40,000 patents assigned to universities since 1972, and we're going to study commercialization. But it's a lot of patents to look at, so we're trying to figure out how to go about doing that. But the point is, this is the patent system working as designed. Now, maybe the government should say, you know what, gene patents are too important. We're going to carve them out of the Bayh-Dole Act. And so we're going to give money for gene patenting research. We expect people won't do it otherwise, but it's got to be free for everybody. That would be okay with me. I could live with that. That's a policy point. But to say that genes are somehow different from all their academic research, I'm not sure works. The government made a decision many, many years ago that patents would be better commercialized if universities did it. That's what happened here. That's what happens all over. There's lots of cases where big discoveries are invalidated where universities did it, and so we shouldn't begrudge the times when they succeed. But at the same time, medical stuff is different, so I'll end it on that. So if people have questions.
Hi, Michael, it's really great to have you back.
Thank you.
I'm really excited to see you later for dinner. I really enjoyed the presentation, and I'm incredibly persuaded by the idea that genes should not be patented. Okay? And so my question, though, is, and the reason I'm persuaded is because I just kept on thinking, what are the arguments? And I think, Michael, you did supply some of them, but I'm still not persuaded, and this is why. It seems to me, and I have a science background, but I'm not a scientist, so I'm a lawyer. So bear with me. It seems to me that genes are natural. So I would even go so far, now I don't know much about combinant RNA or DNA, but it seems to me that even that, it's, why, if we can even patent that, then why, I know what a gene looks like. I know that it has to be only of, certain base, A, G, T, C, and I could just start making different combinations and just set out patents. And why wouldn't I do that right now? I could just sit there, Michael, maybe you can help me later. And then once it comes up, I have these patents, and then if I'm the only one, I get to be the czar of genes. It seems to me that genes are natural, and that they, just because nature hasn't utilized a certain sequence yet doesn't mean it wouldn't. And it seems to me that the policy for this is that we're actually hurting innovation because we're giving a monopoly to certain person who actually decided to sequence something, which is really important for many diseases to know the sequence. I understand that. It's very important. But then they get this patent, and then they seem to have a monopoly. So I realize that my understanding is I actually understand the science better than the law on this, okay? Much clearly, because I could tell by the way Michael's like smirking. But
the law could be wrong. I mean.
Well, I think it is. Not that anyone cares what I think, but it just, can you supply for me, what are the arguments besides you gave some policy, but what is the legal arguments here?
I assume you guys aren't going to take this on.
I can answer, but I mean, under traditional patent law, there are three main things. That patent has to be useful, novel, and unobvious. So theoretically, you just can't patent a combination of nucleotides without having a use for it. So here it was tied to, the breast cancer, identifying breast cancer, whatever, so that this gene had some utility associated with it, or the test had some utility. You can't just patent anything without a use.
So that's part one. It's got to be useful.
Okay.
And then part two, it's not the gene in your body natural. Everything's natural that way. It's got to be separated from the natural state in such a way that it becomes different from what it was before in kind. That is, it becomes commercially or therapeutically useful. And this is something that Learned Hand said 100 years ago.
Okay, Michael, so E equals MC squared is not patentable. You said that. I remember that was like your first faculty colloquium here. Remember? You did that, right?
Yeah, my job talk was everything is patentable.
Yeah, I remember this, okay? And I guess that's what I don't understand, the difference between those two. And maybe I'm just beating a dead horse here, but
E equals MC squared doesn't do anything. But there is a patent on nuclear reactions. Fermi got one. So, in fact, E equals MC squared is not a thing. It's not a machine, manufacture, composition. It's a formula. Some would say it's an abstract idea, but I don't even think you have to get that far. It doesn't fit into any of the categories of Section 101. A gene is a thing. You're not patenting the information per se, but you kind of are. What you're patenting is a thing that looks like a gene sequence. And by the way, when they do gene patenting, sometimes they will figure out the codons that are not, basically the non-expressing codons, the introns I think they're called, right? That those are removed. So they actually figure out which parts of the gene are not doing anything. And so you get a patent on a gene, on just the parts of the gene that are actually doing something, and that can be very helpful. So for example, let's say I isolate the gene that creates insulin in the body. You say, well, that's natural, I shouldn't be able to do anything. But what if I take that gene now and put it in a bacterium, which is basically obvious now? So, and now that bacterium starts squirting out insulin. And that's a much, much, much cheaper, faster, easier way to make insulin than the old way. That costs money to figure out, that costs money to do, and it has great commercial consequences. So that's the argument for why you might have it. Now, when you're talking about medical diagnostics, what you're doing is you're comparing this gene you've created to what's in the human body, and I think that is where people complain less about artificialized insulin made in bacterium than they do about gene testing, because the idea with gene testing is you're taking what you know, information, and you're comparing the gene you pull out of the body with that, and that's just information. That's knowledge. That's not a thing. I'm not squeezing out the protein that creates these tumor-inhibiting effects, although that's probably the next step of research, right? If we know that the gene in the body, non-mutated, inhibits cancer, then we should be researching ways to make that protein for gene therapies for people who don't have it. And to spend the money on, I don't know if that worked. Maybe,
They're working on those things.
so, but not without the research exception, right? It's only
Well, no,
myriad?
no,
or-
yeah, well, for other genes, for other diseases.
Right, but you'd want to do that
And
with
they
this
can
gene.
do it, they can do it in terms of personalized therapy for
Right.
someone who has breast cancer.
Okay.
So they can do that.
So,
So maybe this will be my last comment. Maybe the answer is the research exception then. That seems to make everyone, that
Little
seems to
happy.
get everyone happy.
certainly the professors are.
Well, I think part of the problem in this whole thing is terminology. I mean, you're talking about a gene, and maybe only in science, when you talk about a gene, you're talking about a unit of inheritance that is transmitted from one generation to the next. And that's a classical definition of a gene. And when you say gene sequencing, it is that natural gene that was sequenced originally through technology, which probably isn't used anymore because it's outdated. So that part of it, the sequence itself, the gene itself should not be patented. What I think, when you talk about the cDNA and the method to identify the abnormal sequences from an individual, when they take the DNA and during the process to RNA, it loses all its introns, so you only have the active part of the gene working. That RNA is actually a little bit complementary. It's the same information. The base pairs are slightly different. And then they take that sequence and make cDNA, which is actually sort of like a mirror image of what the original DNA was, so that you could duplicate it and look at it in greater quantities and see exactly, you'd have much more to work with, the same stuff but have more to work with. And see, I think that's where the problem is, because I could see where that process could be patented. I think that process is what it is. It's not the gene itself.
So to me, it seems like simply a matter of degree. I mean, companies want to get as much protection as they can. Getting it through a composition of matter, which is the gene itself, is going to provide the broadest amount of protection, because no matter how you get to that gene, if you produce it by sequencing or whatever new technology comes out, you're protected. And I think that's what people feel uncomfortable about. But to kind of maybe take a step back and look at the policy questions of why it is we want to allow gene patents, even though it may seem a little bit distasteful on its face, is these companies are spending hundreds of millions of dollars to commercialize these tests. In fact, Myriad claims that they haven't made any money on these tests yet, and they're charging $3,000 per test. So
Yes,
it's a quite a bit of money, but it was a monumental effort to get that. I mean, if you take, for example, aspirin, the first aspirin pill is going to probably cost hundreds of millions of dollars, but every pill after that is going to be a fraction of a penny. The question is, we have this patent system set up so that the companies who do invest those hundreds of millions of dollars to create the first pill are going to be protected later on for their investment. So really the question, the way people who favor gene patents frame the question is, do we want these diagnostic tests or not? Because no rational company is going to invest the money to create these diagnostic tests in the first place if they're not going to get patent protection. So really they frame the question is gene patents, no gene patents, that's fine, you can decide the way you want, but as far as an innovative question comes, do we want these tests or not? Because no company is going to produce these tests if they don't have patent protection.
Right, and then the factual question is the government paying for it anyway, and once the government pays for it, is getting there cheap? I mean, that's a dispute we won't resolve here, but that's the real dispute on that part of the policy side. It's actually a factual dispute about what it actually takes, and it may be different in different cases.
One strange thing that I wanted to mention before. Some of the patent, the court said that they were deciding this case under traditional patent law, that these genes were different from those that existed in the body, therefore they are new and patentable. However, they went totally away from patent law in other respects. One of the claims this gene, which I understand has 120,000 units, and the claim basically has 96,000 units, just a question mark in there. So it has a sequence of 20,000 with a big question mark occupying 80% of it in the middle. So, like, if I filed a traditional patent application and I said I claim this pen, and I'm only, I give a drawing of the little tip thing that normally falls out and rolls under your chair, they would send me back my patent application and probably my filing fee and tell me that I should find a patent attorney or something, Or if I filed a patent application on a small molecule and just had the atoms on the end with a big question mark in the middle, they would do the same, But here, the court said, oh yeah, this claim is patentable, but 80% of it is unknown. And when you figure that you've got, how many, if you took 96,000 missing units in there and decided how many combinations, because each one could be 4 different units, okay? They're patenting something that could have, trillions of possibilities there. And they're admitting they don't know what it is. And the traditional patent law says you have to claim and describe your invention in definite terms. And here there's an admission, we don't know what the hell 80% of it is patented.
I might push back a little bit against that. In looking at the patents, the way they claimed it was using a seq ID to the amino acid sequence. And they said any DNA sequence that falls within the parameters of this amino acid sequence. The problem becomes there are degenerate primers, or there's degeneracy in the code. So simply, you can have multiple ways that the DNA will code for that same amino acid. Right. And so the question mark becomes not what is the amino acid sequence, which is enabled and described correctly. Mm-hmm. It's the DNA that codes for that amino acid sequence, and that's where that question mark comes from.
Yeah. And the thing is that obviously even Myriad hasn't figured out what all the mutations are. One of the slides or piece of information that I was looking at before when I was making this presentation, there were only 500 mutations known. Now there are over 1,600 mutations known. They found a lot of mutations or changes in the genetic information that they didn't know what the function of those mutations was. And they still don't for a lot of them. So you have unknown function. Is this a mutation or is it a normal variant? So you have a lot of that going on as well. But why shouldn't some other lab have the opportunity to, look at that sequence and maybe use a different technique and be able to identify, yes, that is a disease mutation or it's a normal variant. Yeah, that's what
I think one of the things that interests me about this topic is the sort of multiple personalities that these compounds have in the wake of patents, right? They're at the same time incredibly small and incredibly huge. They're at the same time that they do nothing and everything all at once. Genetic sequences are, on the one hand, just information, yet on the other hand, they give rise to all the functional protein in the body, right? So if we take inventive activity on a continuum from pure creation from whole cloth all the way to just discovery by luck, where ought to be, in the opinion of the panel, the inventive threshold that a person or an entity ought to have to cross to get its nose over the line to get a patent? I mean, if we can take a small molecule, right, and we know the answer. Diastereomeric or an antiomeric modification constitutes a change. what's the what ought to be the threshold for these compounds, for these molecules? Is it just simply isolation, or does it go to mutagenesis, or does it go all the way to site-directed mutagenesis? What ought to be the threshold?
I mean, I would like to keep traditional patent law in place, but I think the government has to step in, and just like has been done with naturally occurring substances or whatever, I mean, there are limits to it. 35 U.S.C. 101 says, you know, what is patentable and what is not. There are some exclusions, and I think we can just add certain exclusions to it.
Yeah, I'd say it depends on whether you're asking from a patentability point of view or from a patentable subject matter point of view.
The latter.
So from patentable subject matter, I think whether it should be patentable subject matter, whether it's it could be identical, it's patentable subject matter, because it's a thing. A thing can be patented. And then the question is, if it's identical, then it's not new. If it's slightly changed, then maybe it's obvious. And so when you talk about a threshold from pure luck to all this work, which is interesting because if it's pure luck, you actually can get a patent. And if you do all the work, it's like the middle where you're not patentable, but on the ends you are. So my view is that's where you look, but that's an obviousness question. That's not a subject matter question. The subject matter is you got a thing, if the thing can be patented, so long as it's not, you know, in the human body as is. You can't patent my fingernail, but if I clip it off, I can try and patent it. Of course, it won't be novel, it'll be obvious, et cetera, but I still have it. I have a thing. I could try and stop other people from making it. You know, we know what it is, but the problem with it is it's not new. I didn't create it. If you want to look at it as a product of nature exception, that's fine too. But the point is it's still a thing, so it's not like the difference is. It's more, you know, whether or not you meet the requirements to get there.
I agree completely with the other panelists. I think what Professor Risch is trying to make a distinction of is how high of a bar do we want patentable subject matter to be? Traditionally, it's been pretty low. Under Chakrabarty, it's anything under the sun made by man, right? And from that, I think a lot of our biotech industry has flourished because we've had that kind of low bar. And then we use the novelty, non-obviousness bar to kind of surgically weed out the things that we think shouldn't be patentable because it's not new, it's not obvious. But for me, it seems like we're using a tool like a sledgehammer to try to just knock out a whole swath of it. This could potentially kill personalized medicine, I think. Some might disagree with me.
Which way could kill personalized medicine?
Using 101, patentable subject matter, to eliminate gene patents, whole cloth.
Because the idea is no matter how brilliant your personalized tests are, it's invalid. No matter how much money you spend creating something to make people better, it's invalid. Well, if that's the case,
Right.
you know, once it's out there, everybody can do it. So why bother spending the money? That's the
Whereas
that's the
we can
incentive.
use novelty 101 or 102 or non-obvious 103 as surgical tools to kind of get rid of that stuff that's already put in the public eye.
Yeah, but can't you use 101, a trimmed-down version of an exclusion, so you can't patent the gene itself that would allow people to use it, but you could patent drugs that result from the research on it, test methods that result from research on it, but don't patent the actual gene itself.
That would be another option. Yeah.
I think it's
that's what
reasonable.
I think, yeah.
When I view it as information, that's kind of my view.
Instead of a chemical
It's
entity.
all-
Yeah, I guess that's where I am.
It is
They're
information.
confusing compounds because they're information on the one hand and functional compounds on the other. So
They produce functional compounds.
yes,
They produce
yes.
functional compounds.
So do we want to
Yeah.
patent what's looked for or how to look for it?
All right. Why don't we take one more question?
Thank you.
And then go from there.
First, I want to thank you all for coming here today and talking and taking your time to do this. Mine kind of dovetails right into kind of what Roger was asking, and the idea that, Mr. Flynn, you stated that there potentially needs to be a different application to genetic codes. Not so much cDNA or the manipulation of an isolated gene or that sort of thing, that there needs to be a different application just to the natural DNA. And to me, it sounds like you kind of went with what the DOJ said in that particular case, and that, if you're mining for coal, when you extract the coal, it's still coal. It doesn't change it, so therefore, there's no manipulation that allows for one-on-one application. Professor Risch, you talked about DNA being information, a song or a book, which is essentially what it is. It creates that information for the body to function the way it does. So would a potential place, a meeting place, be something along the lines of the ability for the person that found the gene to copyright that particular, on some level, take that kind of idea that it's information and use kind of the same applications that come from informations in songs and books versus the whole patent system?
It's funny you should ask that, because Chris Holman, the guy who's writing a thing on the 20%, either is publishing or did publish in the West Virginia Law Review an article about copywriting DNA sequences. He presented it here about 4 years ago. He was a little late writing it, but he presented it here like 4 years ago at our digital entrepreneurship conference. The idea of copywriting DNA. The problem with it is, ironically, in order to get a copyright, you have to create something. And so if you're taking the information from the cell, then you're not actually creating anything, in which case it is not creative and therefore can't be copyrighted. So it's ironic you can get a patent on it, but not a copyright on it. But it's a good idea. It's a good idea. If it's information, maybe it should be viewed under the copyright standards.
Of course, you could just publish it and put it out there for everybody, and, then it's not new and others can't patent it, so.
Right.
And that's what they've done with some genes. They've just put them out there and let people
So
use them.
to end, this all could be a red herring, because Craig Ventnor, when he was doing the human genome, the private human genome project, was just publishing everything, putting it out into the public domain. So all of this could be a 102B, which is anticipatory non-novelness, because it's all published at this point in time. And a lot of these patents are coming up to expire. Like these gene patents from Myriad, I think expire in 2015.
I think so.
So relatively soon.
Yeah.
So this could all be a moot point. Right.
Nobody said anything about the original ruling.
The Judge Sweet ruling?
The Judge Sweet ruling.
Right. Well, he's been overturned. So.
I know. So you don't care anymore.
So again, that's kind of moot. Okay. All right. Thank you so much.
Thank you.